Hello everyone, myself Akshay Sharma, Assistant Professor, School of Law and Legal Studies in Sage University, Bhopal. And today I'm presenting this video lecture for the course LLB Honors third semester, and the topic is concept of plea bargaining. So we'll move first towards the meaning of the plea bargaining. Plea bargaining is a pre-trial negotiation between the accused and the prosecution where the accused agrees to plead guilty in exchange for certain concession by the prosecution. So in a simple words, it is a kind of negotiation in which the accused he can plead guilty. He admits that he have committed some kind of crime, and on behalf of it or against it or in exchange, he demanded for the lesser punishment. So it is a bargaining where the defendant plead guilty to the lesser charge and prosecution in return drop more serious charges. So it is not available to the to all the crimes. For example, it is not given for the heinous crimes like murder or rape. So, as we see in this photograph, in this picture, that few parties are signing some kind of agreements. So, these are one is accused, other is legal representative, prosecutor, and the victim. So, these are the key players which signs this agreement of plea bargaining. So, next is history of plea bargaining in India. Plea bargaining runs much deeper. It is not a very old concept, but it runs much deeper. It was deliberated for the first time in the Law Commission in the 42nd report. So it is headed by Justice M.P. Thakkar, but significantly, it is detailedly explained in 154th report, which is shared by Justice K. Reddy. So it is coined first time in 142nd report, but it is detailed concept given in the 144th report of the Law Commission, which is given in 2003, significantly through the Malimat Committee report, and the which is before the amendment of 2005 when it is incorporated in the uh, under the CRPC, the Code of Criminal Procedure. Next is the statutory provision of the plea bargaining in India. As we know that it is secured under the Code of Criminal Procedures, and plea bargaining is not an indigenous concept. As we know, it is a modern kind of concept. It is not before 2005 amendment. So it is introduced after 2005 amendment in the criminal law. So section 150, 165A to 165L, which is chapter 21A of the CRPC, it deals with the concept of plea bargaining. So there are three main ingredients which have to be seen or which have to be observed while negotiating or exploring the concept of plea bargaining in any trial. So where there is a maximum imprisonment is of 7 years. So whenever there is an punishment which is less than 7 years or 7 years, only in those cases you can explore or an accused can explore the plea bargaining concept. So where the offense don't affect the socio-economic condition of country. So any socio-economic offense is excluded under the under this section 265A to 265L. So when the offense are not committed against the woman or a child below 14 years. So simply if the punishment of any offense is more than 7 years, if the offense is socio-economic, and if the offense is against child or woman, then in that case, the concept of plea bargaining cannot be explored. Next is types of plea bargaining or types of bargaining, we say. It is sentence bargaining, it is charge bargaining, it is facts bargaining. So what in sentence? So if there is any offense in which the punishment is given maximum of 3 years, Then the accused can negotiate and plea bargaining for the concession of that punishment to 1 year. So that is called a sentence bargaining, when there is a bargaining as compared to the sentence of that particular offense, the punishment. Another is charge. So if there is more than one charge or the gravity of charge, then they can plead for the lesser charge in that particular case. Fact bargaining. They can negotiate on in the terms of facts of the case. They can simply scrap or factually lesser the burden of liability upon the accused when he plead guilty and demanded for the plea bargaining. So these are some landmark cases which is emerged out of the Indian judicial system for the plea bargaining. So there is Murlidhar Meghraj Loya versus State of Maharashtra. It is a case of 1976 in which Honorable Supreme Court criticized the concept of plea bargaining. So as we know, it is not a per se concept, or it is a very old concept. It is something very new. So the judgment which is given in 1976, so the mens rea or the judicial applicability of the judges at that time, they consider the plea bargaining is not a very good concept as for the criminal proceedings. But later on, as if we see in the state of Gujarat versus Natwar Harchandji Thakur in the year 2005, the court acknowledged the importance of plea bargaining. So they said that every plea of guilty, which is constitute to be the part of the statutory process in the criminal trial, should not be understood as a plea bargaining ipso facto. So it's simply says that it depends upon the nature of the case, it depends upon the facts of the case, it differs according to the factual gravity of the case, that such cases belongs to this the concept of plea bargaining or not. So it is not good to say that it is per se very wrong, this particular concept, but it varies to the facts of the case and according to the gravity, of course. Next is history of plea bargaining in United States. In 1976, however, an influential report by the President's Commission of Law, Enforcement and Administration of Justice documented the widespread use of plea bargaining. Through the concept of plea bargaining as adopted into the Indian legal system, as we have borrowed from US. So it is very significant to understand that we have borrowed the concept of this plea bargaining from the United States, but still we have very distinguished practice in our Indian legal system as we compare to the United States. So if we compare both India and the concept of plea bargaining in India and in United States, so there are mainly five heads in which we can categorize and differentiate the concept of plea bargaining in India and in US. So first is nature of an offense. In India, as we have already studied and observed, that any punishment, any offense which is lesser than 7 years, in which the punishment is lesser than 7 years, it only that offense is considered to be the considered in the ambit of this concept of plea bargaining, and even the offense which is not socio-economic, and even the offense which is not against the woman and child. But in US, there is no restriction as compared to the nature of the offense. Coming to next, role of victim in the proceeding. So as we have seen in the picture, which is in the second slide, where we have studying the meaning of this plea bargaining concept. So we have seen all the parties, including the victim, sitting over there and agreeing on the agreement of this plea bargaining. But in US, it is not mandatory that the victim be the part of this negotiable agreement coming under this plea bargaining. Second is mechanism availability for the enforceability. So basically in India, first we negotiate, first the party negotiate between each other, then they comes into the agreement part. But in US, first they come to the table, they've had an agreement, and then they negotiate on the basis of that what punishment should be lesser and what kind of punishment should be given to the accused. So the concept is very opposite to the United States, that on the one hand in India, we first negotiate between the parties and then come to the agreement, but in US first they come to the agreement and then they negotiate. Another is discretion of judge. So there is no discretion of judge in United States, but there is a wide ambit of discretion of judge in the in Indian legal system. If a judge, if a magistrate says that he'll not approved, or he'll not consider this agreement of plea bargaining, then this particular negotiation have no effect and becomes null and void. Finality. So once the agreement have done, once the court have decided in United States, there is no appeal, there is no any other superior authority or superior court which can adjudicate upon the finality of this plea bargaining agreement or negotiation agreement comes out of this plea bargaining. But in India, we don't have the concept of appeal, but we can go for we can go for the writ jurisdiction under this. So it somehow differentiates India from the United States, and the judgment given by the magistrate is not a final judgment, because there is also a remedy for the parties to go for the under the root jurisdiction, not in appeal but in root jurisdiction. As we statistically see this plea bargaining applicability, we came to know that 90% of plea bargaining in US, sorry, the 90% of the criminal cases is negotiated on the basis of this plea bargaining consent, but in India it is only up to the 10%. If we see with an example, if you guys have watched the English uh, series Suits, you came to know that many of the cases they have solved on the basis of disposition, which is the out of the court settlement. So it is a very good example of this, the concept of plea bargaining, that how the US judicial system negotiate these criminal cases out of the court. The landmark case of United States, it is Bradley versus United States, is a landmark case in which they have discussed the issue of the constitutionality of the plea bargaining. The judge in this case held that the plea bargaining is to be a legitimate and constitutional mechanism, however, advancing a few apprehensions about the potential of misuse of this. So this is a mixed approach of a judge in this case, that it is a good concept, but it has a wider scope, it gives a wider ambit uh, that it can be misused by either of the party. But then again in Stanbello versus New York, that there are various other resources available to the people in case where the attempt made in the plea bargaining are impeded. So that's all from my side. Thanks a lot, and hope you have enjoyed this video. And if you have any suggestions and views regards to this concept, you can leave in the comments box section, and please like and subscribe this video.